Morning.
Good morning.
Thank you for coming and taking part in this interview.
My
I just have
pleasure.
a few questions about mediation. First of all, please introduce yourself.
My name is Arnold Barba. I'm the Chief of Staff to Dean Karen here at Pepperdine Caruso School of Law, also the Assistant Dean of Professional Formation, and I've been here since August of 2022.
How would you explain mediation in plain English?
Mediation is the opportunity for litigants, parties in a lawsuit, to have a voice in the resolution of their dispute, where they could come together and resolve their dispute, sometimes in a creative way, in order to have some control over the outcome.
Do you recommend using mediation to your clients?
Well, mediation, I think, is something that should always be considered by litigants, and especially by the lawyers that represent the litigants. It needs to be part of the toolkit that lawyers have who advocate for their clients, looking for a resolution for them, because it's a way to involve their clients in a direct way for a compromise that could mean that their business, their family, their livelihood could survive an outcome that otherwise they'd have to face in a tribunal with a judge or a jury. And it also keeps the litigants informed as to what their exposure is in their case. And a better informed client makes for a better informed strategy.
What factors should parties consider to evaluate their case and determine if mediation is appropriate?
The factors that, well, to begin, the way I approach it is mediation is almost always appropriate. And that's because you could learn so much from the mediation process, even if it's not successful. You get to hear the other side's view of the facts of the law, and that can only help you inform the strength of your case, the weakness of your case. You want to rely on accurate information and also learn about what your opponent has to say or what they have to present along the process. So if you're not interested in that, then maybe you're not going to mediate, but who would not be interested in that? So in my view, it's the exception where you would not want to mediate. What is that exception? That exception is if you are across a party that has no interest in resolving the dispute at all and is in the process for the sole purpose of destroying your client's business, where even an adjudication isn't the ultimate goal, it's just the fight. If there is no interest on the other side to resolve at all, then the mediation will not result in a resolution. But even then, a mediation will tell you that. A mediation will tell you what the intents and purposes are for the other party's litigation. So even then, there's no strong reason against it.
What are benefits of using mediation to resolve a dispute as opposed to going to court?
Well, there are many benefits to mediation over litigation. One is you have more control over the resolution of the dispute, what it looks like, more control over its timing, more control over how to fashion a resolution that could work for your client. Number two, the cost of litigation is exceedingly high. Lawyers' fees, court costs, the emotional toll on some clients, the business toll on some clients. Business clients are not in the business of litigation. They're in the business of whatever their going concern is about. And litigation can be a huge distraction for the brain trust of the company, a huge distraction of the resources the company needs to invest in its future business, present business. So mediation is a way to cut costs and resolve disputes using the power of negotiation centered on self-interest, mutual self-interest.
How can people find and select the right mediator for their specific dispute needs?
Well, good mediators are often talked about. Their reputation precedes them. And so word of mouth is a very good place to start. The other good place to start is the other party's recommendations. If the other party likes the mediator because the mediator is trustworthy, then that's a good place to start considering whether that's a good mediator for you and your party. You don't, of course, want a mediator that is biased or inclined to one side over the other. But if the other side can recommend someone that they're trusting as honest, then that's a great place to start yourself. Because if you agree to theirs, then you know that that mediator has the ear of the other side in the process. And that's what that mediation needs for success. Both parties to listen to the mediator. And then subject matter expertise is also something that can be helpful, especially if it's a nuanced area of the law or a nuanced area of industry, then that can be helpful as well.
What are the potential benefits and drawbacks of sharing or not sharing mediation briefs? And how can party strategically approach this question?
Well, the benefit of sharing a mediation brief is you educate the other side about the strength of your position, and you can start the discussion as to what a resolution might look like before the mediation process begins in person. And so oftentimes a mediator would welcome the parties to start that communication early through a written brief. The downside is potentially you could reveal some of your strategy or the strengths of your case in a light that they had not seen before, and give them an opportunity to counter move to that. But those concerns can be mitigated. For example, a party might write one brief that they'll share with opposing counsel and a separate brief for the mediator's eyes only. And that's been a good strategy in the past for me and for my clients. And so that's one way to mitigate against the concern of disclosing strategy too soon.
Okay. Can you describe one of your most memorable mediation cases without disclosing names?
Sure. This is a small case that I had. It's significant not because of the size of the dispute or the amount in controversy, but because of how it captured the human dynamic. What makes mediation necessary, I think, for dispute resolution, but at the very least successful for dispute resolution, is because it's really human. It's a very human experience. Human beings bring to a dispute emotions, investments, financial or emotional, presuppositions, assumptions, conclusions, and those need to be understood for there to be a resolution. And so in this particular mediation that comes to mind, it was a small matter. We represented a company that invested in real estate. Part of their business model was to buy low and sell high, flip commercial or residential properties. And they found a condo that was in disrepair, had a tenant in it who had burnt half the residence down because of an accident with a cigarette. They were willing to purchase it at the right price, and they struck a deal with the executor of an estate who was selling the property for the estate. The executor tried to back down or back away from the deal because she had second thoughts about whether she had been able to procure enough from the purchase price for the benefit of the beneficiary, who happened to be the person living in the residence that had almost burnt it down. Our clients, despite having all the disrepair, were still willing to go with the deal and did not want to allow the deal to be lost. And so we had a mediation of that dispute, which was part of the requirement of the escrow agreement of the deal, if I recall correctly. We had a joint session. The representative of the estate, the executor, was there. I was there, and the mediator was there. And I had a sense that this was an emotional decision for her, and so I allowed her to, in a joint session, to exclaim or proclaim her reasons for what she was doing and explain why she had decided to try to renege on the deal. And she spoke fluently and eloquently about all the emotional concerns that she had for the beneficiary. After she was done, I commended her for her work and her care for the estate and the beneficiaries, and I just invited her to honor her word, that it was a fair price, looking at fair objective data, and that she had discharged her emotional obligations, and we asked her just to honor her word, and she just needed to hear permission like that. And within 2 hours, the deal, or the dispute, I should say, resolved amicably.
That's great. How can we encourage individuals and business to use mediation?
Well, I think that the beginning of that campaign would be to convince lawyers and judges that it's a great use of their time and talent. I think that's starting point number one, for lawyers to understand that to win means to obtain a result for a client that makes sense in multiple ways, the long-term, short-term, one that is mediation is a solution or a tool that is client-centric, right? Lawyers really would make more money if every case were to go to trial, of course, but what's in the client's best interest? We as lawyers are fiduciaries, and what's in the client's best interest is for us to resolve their disputes as soon as possible. And so when we have buy-in from the fiduciaries who are looking out for our clients, then those lawyers, those counselors, can give counsel to their clients and explain to them why a mediation would be a good way for them to resolve their dispute. And even if it doesn't resolve there and then, it could be a good step towards resolution for a subsequent mediation, or we could learn information at a mediation that will be necessary for a resolution at trial, not through the disclosure of information per se that is not usable, but rather by learning about what the case is about for your client's opponent. You get more information through mediation than just by staying siloed and silent. You need to learn more. To resolve disputes, you need to learn more.
And the last question, in your opinion, how can the mediation process be improved?
The mediation process can be improved if the practitioners are better trained at mediation, not just a professional mediation group of retired judges or experienced attorneys that could help mediate disputes, but also the the advocates. If the trial lawyers, the litigants, litigators are able to have an understanding as to approach and be able to set aside their own emotions that sometimes get wrapped up in the fight and play more of the role of counselor as opposed to prize fighter in the moment. Not completely, you're still advocating, but advocating in a different process, one in which we're trying to mend fences, not tear them down. That's a different skill set for an advocate to have, and it'd be great for advocates, for counselors to have that training so that they could not, end mediations in a way that is only harmful to themselves, but rather give clients a meaningful opportunity to resolve disputes.
Thank you, Professor Barba, for your time and sharing with us your knowledge.
My pleasure.